be an independent unit next year October. Nikiwa rais nitambulisha nyinyi pale mlikuwa. Nyinyi ndio nguzo ya taifa.
Thank you, my lords and my lady. My name is Elisha Ongoya. Number one, I have reflected on a number of unjust trials in human history. The trial of Sir Thomas More, the trial of Socrates, and even the trial of Jesus Christ. One element characterizes these trials. When you read history, there are trials that are carried out with predetermined outcomes. Those who are taken through the trials are taken through the motions for the sake of it. My learned friend, Mr. Wachira Maina, whom I've had the chance to work with, reminds me all the time that behind every constitution lies a moral idea and a moral expectation that there will be good faith compliance with the commands of that constitution. In fact, Mr. Wachira Maina informs me, and I believe him, that in management theory, there is a concept described as malicious compliance. It informs me that there is a legitimacy gap that is wider than the Pacific Ocean between good faith compliance and malicious compliance. I want to persuade you that the motions that the first petitioner was taken through at the National Assembly and the Senate of Kenya passed the test of malicious compliance. The danger of allowing malicious compliance to go unredressed is that it injects an irredeemable legitimacy gap in constitutional processes. The second inspiration that I wish my lords to bear in mind as you determine this matter was set out by the Court of Appeal of Kenya in the case of Martin Nyaga Wambora and 3 others versus the Speaker of the Senate and 6 others. This matter traversed our entire superior court system. I'll have a very emphatic of which particular court I'm referring to when I refer to the Wambora case. So I'm looking at the Court of Appeal 2014. In that matter, the Court of Appeal began by setting out what would inspire it as it writes that judgment. So you look at paragraphs 2 and paragraph 3 of the 2014 Wambora case at the Court of Appeal. The Court of Appeal observes that, I quote, "No parliament, no official, and no institution is immune from judicial scrutiny." I say this because to such other debt as we shall defer us to, some people will take this stand and tell you that there are political issues here that are immune from your scrutiny. The second inspiration that the Court of Appeal set out in the Wambora case was that it is the Constitution, not Parliament, not the executive, not the judiciary, which is supreme. It is the Constitution. I stand here to canvass one substantive question, a continuation of the threshold concerns surrounding the motion, particularly as eventually approved by the Senate. Your brother, Mr. Justice Bahati Mwamuye, has observed in the now famous Kawira Mwangaza case that watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. That's the big risk that our constitutional order is subjected to if we allow what happened in this country, culminating into the resolution of the 17th of October 2024, to stand. It's a threat to confidence in our constitutional democracy itself. Allow me just to reiterate one question that has bothered me, and my learned senior colleague, Senior Counsel Paul Mwita, has touched on it. On 17th of October 2024, when you go through the Hansards of the Senate that I will draw your attention to in a short while, the Speaker of the Senate delivered a communication from the chair, an actual ruling, which informed the members that the first petitioner was in fact indisposed and not available to be heard as guaranteed by law. My lords will agree with me. It requires extremely compelling reasons to insist on proceeding with a case where the subject of that trial is indisposed. It must be exceptionally compelling reasons, not just reasons. When you deliver this judgment, because this matter, I have had the misfortune of sitting on the front benches of this case from the time this matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because my learned colleague, Mr. Dudley, will take you through the timelines for impeachment in Article 145, as read that one for the Constitution. But even after the Speaker erroneously said, we have a timeline of Saturday. They had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. I would want to read in your judgments, my lord and my lady, through what logic this court will allow that decision to stand, if no other decision, that particular one. That for no reason, we are not saying the heavens will come down falling. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason. They simply said, we will not give him the benefit of those 2 days that the Speaker has said we still have. Let's go on record. The Speaker too was wrong. But there may have been some veneer of good faith. If they had said it's okay, because we have 2 days, let us give him the 2 days for whatever it is worth. They said, even that, we are not going to give it to him. On the threshold questions, the matters that I'm specifically tasked to bring to your lordship's, ladyship's attention are the following. Number 1, Article 150, Clause 1 of the Constitution sets out the constitutional textual threshold for removal of a deputy president from office by impeachment. And it says is on the grounds of gross violation of a provision of the Constitution or any other laws. Secondly, it says is on the ground of serious reasons to believe that the deputy president has committed a crime under national or international law. Serious reasons. I'll be making out a simple case that the National Assembly really disappointed the country. To approve a motion that there are serious reasons to believe that the deputy president has violated a provision of the law, section 132 of the Penal Code, which has been declared unconstitutional, null and void, is a locus classicus of lack of seriousness in the reasons. And thirdly, the standard of gross misconduct. Let's face it, my lords, my lady. The drafters of this constitution could as well characterize these wrongs as violation of the constitution, because that's also a wrong, or reason to believe that the DP has committed a crime, or misconduct. Those are wrongs. But they were particular to add these descriptive words, gross, to the violation, gross to the misconduct, and serious to the reasons. The conclusion I draw from this is that they set a very high threshold for removal of a deputy president from office. Our courts have followed cue. I would start with the Supreme Court, sample 2 decisions there, go to the Court of Appeal, sample 1 decision there, then go to the High Court and sample 1 decision there. From the Supreme Court, the decision of Sonko versus the County Assembly of Nairobi City and 11 others. Yes, yes, we do. Yes, we do. Correct, correct. Okay, okay. I'm highlighting, my lord, so I was avoiding reading them. So I'm drawing simply because if I have to take you through the pages, then it means I have to actually take you through the submission themselves. I'm just highlighting salient aspects of those submissions so that we save on time. Thank you. So that in Sonko versus the County Assembly of Nairobi City, I beseech this court to look at paragraph 161 of that judgment. The Supreme Court observed that the grounds for impeachment and removal from the office must be substantiated. The grounds for impeachment and removal from office must be substantiated. It means, my lords and my lady, the motion mover and his supporting cast of witnesses must show us where is the supporting evidence for each of those grounds. They must show where the supporting evidence is. Because substantiation simply means adduction of adequate evidence to lend credence to the ground. The Supreme Court then sets the standard as what has now been called the intermediate standard. Not so low as to be on a balance of probabilities, and not so high as to be beyond reasonable doubt. you will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They'll be removed on similar grounds. And you'll see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, and I quote, clearly, all the words used to describe gross express some extreme negative conduct. Not just negative conduct. It says extreme negative conduct. Then it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature that would warrant removal of a judge from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, set that standard in the Martin Nyaga Wambora and 3 others. I'll just refer you to paragraphs 42 through 45 of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's the one I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were 2 consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS. that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you will find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN 10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I would invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had 1 witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence-in-chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam-in-chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam-in-chief and perhaps the 3 hours for our cross-examination of the National Assembly witnesses and perhaps the 2 hours for our exam-in-chief. So we are not taking any more time of the Senate. We're just reordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by wave of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in exam-in-chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I will start with the ground number 4 of the impeachment motion. The particulars of that ground will be found at paragraph 34 of the motion itself. The particulars of ground number 4 will be found at paragraph 34 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Gachagua. The particulars state that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. It is a requirement in impeachment proceedings that the impeaching house cannot introduce any new grounds at the Senate stage. They are held to account on the grounds as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. One, what does Article 160, Clause 5 of the Constitution provide? It provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground number 4 and particulars of paragraph 34, it is alleging that the threat to take a judge to the Judicial Service Commission is a violation of Article 160, Clause 5. I wonder, their lawyers are here, they will tell us. In fact, some senators are actually here, they will tell us. How does Senate read Article 160, Clause 5 as against Article 168, Clause 2? Because Article 168, Clause 2, constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168, Clause 2 process, how can that be a violation of Article 160, Clause 5? I was taught many years ago, I hope it's still learning today, the Constitution is not self-annihilating. We cannot read Article 160, Clause 5 to destroy Article 168, Clause 2. So that the National Assembly brought a case to the Senate that a claim by the Deputy President that he is going to file a petition against Justice Esther Maina is a violation of Article 160, Clause 5. The Senate approved that ground for removal of the Deputy President. Now, let's not lose focus of this, my lords. The express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If you look at page 60 of the Hansard of 16th October 2024, It's on the attached to the affidavit of Jeremiah Nyegenye as Annex J N10. The following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question. Do you still stand by that part of your allegation that he has not presented the complaint to the Judicial Service Commission as at that date? The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that he's claiming the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it be said that in view of this concession by the motion mover, that ground had been substantiated, that it passed the threshold? The third aspect I want my lords to reflect on when you retire, you can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. A judge has had a case and delivered a judgment and become functus officio. Can a verbal criticism of the manner in which that judge conducted herself in that case constitute a violation of the decisional independence of the judge? That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Can a verbal criticism of a judge, because of a decision she has already rendered and become functional official, amount to a threat to the decisional independence of that judge? Which decision? She has already rendered the decision. I submit to you, my lords, that it is actually good democratic practice to subject judicial decisions to heightened scrutiny. It is good practice. It grows judicial accountability. And therefore, what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. The two grounds that I want to deal simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 5 accused the Deputy President of gross violation of Articles 3.1 and 148.5a of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the Deputy President, that there were serious reasons to believe that the Deputy President had committed a crime under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Those were the two grounds. So, a ground must be supported by particulars that's what the Supreme Court has said, then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Ground 6 had no particulars of its own. Instead, what the drafter of this motion, in his drafting wisdom, did was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, the drafter didn't supply particulars. Instead, he said the particulars in support of ground 6 are the grounds set out in the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific acts or omissions constituting the wrongdoing. The National Assembly went to the Senate and said, we are charging the Deputy President in ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3, and 4. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that the grounds, the charges in impeachment are framed in the same manner as charges in a criminal case. This court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR. The case of LKO versus Republic, 2022 EKLR. And the case of Etiang versus Republic, 2022 EKLR. I'll just refer to one because they make the same principle. Yes, Zongudi said, and I quote, the problem I find in the charge sheet is one of multiplicity of charges. Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. This may result in violation of the right of an accused person under Article 50, Clause 2, Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that the acts in ground 1, 2, 3, 4 are the same acts that constitute the ground 5 and ground 6, these 2 grounds were barred for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the 2 grounds were approved by the Senate as constituting the basis for removal of the Deputy President from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particulars set out in 1, 2, 3, and 4, and ground 5 on the particulars set out in the grounds 1, 2, 3, and 4, but acquitted the Deputy President of grounds 2 and 3. And remember, they gave no reasons for convicting. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chell Dudley, will take you through in a short while. Then finally, ground one. Ground one accused the Deputy President of gross violation of Articles 10.2a, b, and c, 73.1a and 2b, 75.1 and c, so 75.1c, and 129.2 of the Constitution, and Articles 47.1 as read together with Articles 131.2c and d of the Constitution. In summary, my lords, these were the grounds that accused the Deputy President of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. My learned colleague, Mr. Tom Macharia, took the motion mover through cross-examination on this ground. You will find that at pages 88 to 94 of the Hansard of 16th October 2024. So a number of things emerged. I just summarize them. Number one, the motion mover confirmed that the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion mover confirmed that as a fact. Number two, he confirmed that the Kenya Kwanza Coalition was formed of pre-election coalition agreements involving various parties. Number three, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my lord, this must come out very succinctly from me. It bears that PA is the party whose party leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to sharing of government. And they expressly spoke about sharing government positions and sharing resources. You'll see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You'll see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You will see positions, the leader of Ford Kenya being promised the position of the Speaker of the National Assembly and certain cabinet portfolios and principal secretary portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question, therefore, is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that kind of manifesto or that kind of pre-election arrangement at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Sonko decision that I have just referred to. If you look at the High Court Sonko decision at paragraph 258, the High Court says an impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. If the people of Kenya had gone to the 2022 elections on the strength of these pre-election arrangements that talked about shareholding, it follows that they had a chance to revisit that question at the next election cycle. That's what the High Court is telling us. But, my lords, the more interesting one for me is at page 95 of the Hansard of 16th October 2024. You'll find the following very interesting conversation between Counsel Tom Macharia and the motion mover, Ecomas Mwenge Mutuse. I'll briefly take through the conversation, my lord, but you will take note of the pages and revisit it when you retire to do duty of writing judgment. Tom Macharia begins by playing a video to the motion mover and puts the question, who is speaking in that video? The motion mover, Mwenge Mutuse, responds, the President of the Republic of Kenya, Honorable William Ruto. Tom Macharia then poses the question, which words did he use? What did he say to the people of Murang'a? Mwenge Mutuse says he has appointed many of the locals into his government. Tom Macharia prods further, did he say, nyinyi watu wa Murang'a ni shareholders wakubwa wa hii serikali? Mwenge Mutuse says, yes, he did. The people of Kenya have no difficulty waiting to assess their president at the next election cycle in 2027 following this conversation. The question we want you to deal with is this. Why is the president's reference to the people of Murang'a as shareholders in his government acceptable political rhetoric? And a similar reference to the people of Nandi and Kericho, because those are the areas mentioned in the motion, by his deputy, an impeachable offense. It's worth noting that when you read the conversations I've told you at pages 88 to 94, you will find that the person who witnessed the pre-election pacts in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, the National Assembly had no difficulty approving it now to become the deputy president. It is that uneven-handedness that we want this court to ask itself this question. Did the National Assembly find a wrong, then sought to establish who is the wrongdoer to be punished, then found the deputy president? Or did it find the deputy president, then asked, what wrong can we put on him to punish him? Which is what appears to me to have transpired in this set of circumstances. I have taken you through the 5 grounds that were approved by the Senate to demonstrate to you that they were bad for multiplicity. That's grounds 5 and 6. They fell short of the threshold as set out in Article 150 of the Constitution, as expanded upon through judicial interpretation. And therefore, generally, they could not found a motion for removal of the Deputy President from office. While principally, therefore, beseeching this court to allow this petition, allow me now to invite my learned colleague, Mr. Chell Dudley, to take you through the reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the Speaker of the Senate fell way off the mark. Mr. Dudley, you're welcome. Thank you, Madam.